I wanted to thank Centennial Institute and Colorado Christian University for live streaming me in. This is awesome. And I wanted to thank them for the platform that they have given me as a launching pad to being where I'm at right now. A lot of professors at CCU inspired me to go to law school, including Dr. Shoemaker, including Dr. Essery, so I want to thank them for that. I have a picture here of me and Jack from a couple of weeks ago, and I drove through Colorado on a family vacation, and I was working at Centennial Institute a few years ago when he made a cake for John Andrews, and Jack always jokes that he jokes to my husband that he has a photo of my husband's wife on his computer because he has a picture of that cake and me holding the cake in his computer. So I always think that's funny. So Jack is a good friend. He'll be back in Nebraska for a banquet with my husband's organization in October. And he has also come out to Nebraska to testify in the Nebraska legislature, trying to stop a bill that is written exactly like the public accommodations law that was used as a sword against him in Nebraska. So we're really thankful for him. And one last thing, I am teaching the Constitution to middle schoolers this Friday for Constitution Day. So I think it's fitting that I'm doing this event and then also working with middle schoolers this upcoming Friday as well. I kind of want to talk about some of my personal experiences, how I got to where I am right now. And then I thought it would be good to kind of walk through the federal jurisprudence, so what's happened in the courts for religious liberty on the federal level, and then going into how Congress has responded with that, what it looks like in the states right now, and then kind of arguing why it is so important, like what Dr. Shoemaker was talking about, to be focusing on a lot of these issues at the local level as well. So I'll start with my experience with ADF. I was a Blackstone Fellow in 2017, class of 2017, and it was really a life-changing experience. ADF is on the front lines of all of these religious liberty battles, free speech battles. They've won their last 9 cases at the U.S. Supreme Court in the past decade. They're really successful. They really believe that all people should be treated with dignity and respect, and that all faiths should be protected with the religious liberty that we have in America, and that's really their goal. So that has been a great experience. I've had, again, incredible mentors at CCU who have sharpened the way that I think about religious liberty and attack these issues, really inspired me to go to law school to fight on the front lines of the religious liberty battle. And I've also been really blessed with a great law school professor. His name is Rick Duncan. He does do a lot with the Federalist Society nationwide. And I took Constitutional Law 1, which is just the general constitutional law course, a First Amendment constitutional law class from him. I took Constitutional Law Seminar, so I wrote a paper on the NIFLA case, which was the California case where they were compelling speech of pro-life pregnancy centers. And I got to research and write a paper on that. So I've had a really good experience and have had a lot of experience and tried to focus really on the First Amendment issues throughout law school. So I want to start with really why our Constitution is so important. And Dr. Essery touched on this, and he was saying that it is the oldest surviving Constitution, and there are reasons for that. And I think number one of the things that makes our Constitution unique is that it's a written Constitution. And that sounds crazy, it sounds weird, but in reality, a lot of constitutions aren't even written down in a document. So that is something that makes our Constitution unique. Number 2, it recognizes natural rights. It sees all human beings as holding inalienable rights that are granted by God. We all know this. We've been taught this, but we sometimes don't realize how unique that is for a country. And number 3, our Constitution's framer structured our government to secure those natural rights. And this was radical. This is what makes the American Constitution experiment so unique, is that we have framers who say you hold rights, and we are going to, in this document, grant the government some power power to exercise over these rights, but your rights don't derive from the government. So you look at religious liberty and religious freedom. That is something that the founders believe is inherent, that we should all be able to exercise. And the government has a very limited amount of power over that right. It should, and we're seeing that change over the past couple of decades. Neil Gorsuch was labeled as a natural law originalist in an article recently written by the Witherspoon Institute with Ryan T. Anderson. And that's what they called him, because he recognizes that's really what the founders understood. All Americans, all people to be holding these natural rights, and government secures those. So it's really what makes the American Constitution and what makes America, the great American experiment, so unique. And I think it's important to recognize those. So I want to go into what the jurisprudence has looked like over the past 60, 70 years for the First Amendment, specifically religious freedom, and then how that has translated over into the states and what the states should be doing about it. So you have in around, I think it was 1940, that the First Amendment was incorporated against the states. So before 1940, the First Amendment only applied to the federal government, because it says Congress shall make no law. It doesn't say the states shall make no law. It was binding to Congress. So it wasn't until 1940 that the First Amendment even applied to the states. And then starting in the 1960s, the U.S. Supreme Court started developing jurisprudence that was really in favor of religious freedom. So they said that if your free exercise rights are unduly burdened in any way, then the government has the strongest level of scrutiny put against them in order for them to prove that, in order for them to show that it's okay for them to burden your rights. So it was very hard for the government to win if they were burdening your religious freedom rights. And then you have in the 1990s what's called the Smith case. And this case is what says if a law is neutral and generally applicable, then regardless of the undue burden that it places on your religious exercise, you don't have a claim. So it's a very low level of scrutiny that the U.S. Supreme Court has to apply to these laws if it's neutral and generally applicable. So what happened is Congress came in and enacted what's called RIFRA, the Religious Freedom Restoration Act. And what that did was reestablish what happened in the 60s, saying if your religion is unduly burdened, then the government has to meet strict scrutiny. And what ended up happening with RIFRA is it was invalidated against the states. So it applied at the federal level, but didn't apply at the state level. So once RIFRA was invalidated against the states, then Smith, the neutral and generally applicable rule, which you see that language in the Masterpiece case, that then applied to the states. That was the floor that all of the states had for the First Amendment. So you had a few responses from states. Some states passed their own RIFRAs. I know Colorado has tried to pass a RIFRA, and it was not successful. I'm not sure how many years ago that was. Some states have said our state constitutions provide more protection than the federal First Amendment free exercise clause. And that's okay because the federal constitution is a floor, not a ceiling. So you can grant more rights as a state, but you can't take away rights from what is in the federal constitution, if that makes sense. So some states said our constitution is actually stronger than what the Smith rule says. And some states, including Nebraska, and I'll talk about this, have said, you know what, our religious liberty clause in our state constitution just means exactly what the Smith case said. So we're just going to apply that really low level of scrutiny to religious freedom cases. So one of the things that I have focused on in law school is this issue on the state level, where our Supreme Court decided to say, we aren't going to look at the original meaning or the original intent of our state constitution's religious freedom clause. We're just going to apply whatever the federal government says, whatever the U.S. Supreme Court says about the federal Constitution. And so I am publishing a law review article about that, saying that's really not what states are supposed to do. We have this history that we can look at for what the meaning of it's a conscience clause, what our conscience clause says in our state constitution. And that's really what the court should be looking at when it's looking at religious liberty, religious exercise claims in Nebraska. So I'm really hoping to show we really should have stronger religious liberty protections in Nebraska than even what the U.S. Supreme Court has said the Free Exercise Clause requires. So the reason that I'm so focused on this and that I have written on this in law school is because I really do think that we should be focusing more on the state level than we tend to do. And I think watching all of these really big battles at the U.S. Supreme Court is really exciting, and it can get us really hyped up. But at the same time, a lot of the battle is happening in the states and in the state legislature. So like I talked about, Jack came to Nebraska to testify to stop a bill that had the same language as the public accommodations law that was used as a sword against him. And that's happening in Nebraska, which is a very conservative state, and that could have harmed a lot of people in Nebraska. So being able to have people on the front lines in states making sure that really good law is getting passed and really bad law is being stopped, I think that is really where we should see morality flourish, is in our small local governments and our communities, and that's one way to do that. So other than that, that's really mostly what I wanted to talk about. I think that religious liberty is something that once it's gone, everything else starts falling away, and it's really hard to get back from there. So I really appreciate Centennial Institute and CCU having this panel, for Eric Baxter and Eric Hall, Dr. Shoemaker, Dr. Usry, for all of you being on the panel. And thank you for inviting me to give my little blurb about this issue. I'm very passionate about it, and I really appreciate your time.